Hello, this is Alan Gassman. Welcome to Thursday, June 9th, 3 p.m. I am here with a very good lawyer, Sheldon Mayer, and a very good rabbi, Ari Marburger. And we are going to talk today about what estate planners need to know when planning for Orthodox Jewish families, and also to some extent, what Orthodox Jewish families may be thinking about when they help to educate their estate planner. And I'm going to introduce Sheldon. Sheldon's going to lead this discussion. He's going to introduce Rabbi Marburger. Sheldon goes by Shimmy with his friends and clients. He's a partner in the Greenwald Weiss law firm in Brooklyn, New York. I can tell you that he is a very knowledgeable and very conscientious estate planner, someone who really cares about his clients, and someone who knows how to navigate the tax law as well. He graduated cum laude from Washington University in St. Louis and also has an LLM in tax degree from Washington University. So Sheldon, I'm going to let you introduce Rabbi Marburger and lead this discussion, and I'm really looking forward to learning a lot here today.
So thank you for the introduction. I would say that most of what I know comes from you as far as the tax planning and estate planning. Rabbi Marburger has been a mentor of mine when it comes to Jewish law issues and estate planning for many years. He's very well regarded in the field of Jewish monetary law. As a whole, serves as an arbitrator in religious arbitrations and is a published author as well. And I just learned that he's been invited a couple of times to Harvard Law School to give lectures on Jewish law. So it's an honor to have him. And I'm going to allow Rabbi Marburger to lead a lot of the discussion, particularly as it relates to Jewish law, because he's quite the expert. And I will try to chime in as well in terms of the practical things that Orthodox clients may be thinking about and some of the issues that come up with the healthcare praxis and big wills that estate planners are always doing for their clients. I think initially, it's important that we have some sort of a definition, a working definition of when we say Orthodox Jewish families. What does Orthodox mean, and who would you say that includes?
Okay, thank you, Sheldon and Alan, for inviting me here today. To start off with, I'll start off since this is a legal conference. I'll start off with a disclaimer, and that is Orthodox Jewish family is a very broad term, and I don't know that there's one clear, specific definition. Orthodox Jews come in all shapes, sizes, and flavors. In a general sense, Orthodox Jews means that they follow the Torah, the oral and the written law that was given at Sinai to Moses. To translate that into simple terms, for an attorney, it means the clients probably keep kosher, observe the Shabbos, Saturday they won't be doing any work, etc. Within Orthodox Jewish families, there's quite a range from modern Orthodox to Hasidic. Many of the things that we're going to discuss today are really going to be common to all types or all people who consider themselves Orthodox, but not all. There will be a subset of any given topic that we're going to talk about. Not everyone will follow all the rules quite as the way I'm presenting it. I'm a rabbi. I can give my opinion, no one else's opinion.
Okay, thank you. And now that we maybe also if you could define for us, because I know the term comes up a lot and may come up in this discussion, the term halacha and that sound, the halacha, that ch, where did that come from? And just explain that lingo and maybe define that for us.
Okay, sure. So as far as the term halacha, the loose translation is Jewish religious law. And I think many people are familiar with the idea of kosher, that there are dietary restrictions on what a Jewish client will eat. You can certainly offer them a can of Coke or a soda. it's highly unlikely they're going to accept an offer of a meal or a sandwich that you hand to them because of the kosher restrictions. But halacha really is much broader than that. It encompasses the idea of Shabbos, or Sabbath observance. Orthodox Jews do not do any form of work on Saturday or on Shabbos. To be more specific, Shabbos begins Friday at sunset and continues through Saturday sundown Saturday night. During that period of time, an Orthodox Jew will not drive a car, will not answer the phone, he will not even see your emails. So regardless of how critical this thing is, you're not being ignored. Your client doesn't even know you are trying to reach him during this period. That applies to every Saturday. There are Jewish holidays as well. You know, in America, you have Microsoft Outlook. They're generally, or Google Calendars, whatever you're using. They generally mark off the holidays pretty clearly. And again, just don't expect any sort of response during those periods. What is a little bit less well known is that halacha refers also to financial matters. Jewish law has a very developed and very specific set of rules about commerce. My day job is actually as a dayan, or as a rabbinical judge on a bezdin, which I guess loosely would be an arbitration panel. And I deal with financial disputes, ranging from small, somewhat petty issues between neighbors to complex commercial litigation. Halacha has very specific rules and structures about all of these matters, and it's kind of a broad term. Now, just to focus a moment on the word and the halacha. One of the things that you'll notice if you have Orthodox Jewish clients is that many of them have funny names. And the reason for that is they're simply Hebrew names. And it's a bit difficult to pronounce some of them, partially because you may not be familiar with the names. But the other reason is that some of the sounds of these names simply don't exist in the English language. The ches, or the cha, in halacha, it's written CH in English, but it's a ch sound which a typical American has never made and is not capable of doing it. But relax, your clients don't expect you to get their names right. My wife's name happens to be Chaika Chana. I don't think anyone has ever pronounced that name correctly, so it's okay. They're coming to you for legal advice, not for articulation lessons, and just do your best. They will not be insulted or offended if you butcher their names.
Very good. Okay. And so, Alan, feel free, as well to chime in with any questions. But let's just assume that I'm an estate planner, and I know my estate planning really well. And I have a Jewish family that, an Orthodox Jewish family that comes in for an estate plan. Can I just do my regular job with them? What do I need to know? What do I need to know that they may not know themselves that they need to be aware of?
Mm-hmm. Okay, great question. So to start with the obvious, if they're coming to you, they are coming to you for legal advice. They're coming to you because of your expertise in the civil estate planning laws, tax laws. They're not coming to you for religious advice. They'd call me for that. So certainly your primary goal is, and what they're turning to you and relying on you for it, is for the legal advice. A couple of pointers, just so that you have a better understanding of where the client is coming from and some of their concerns or things that may come up through the process that you wouldn't typically see when you're dealing with a non-Jewish client, is that, as I mentioned before, halacha, Jewish religious law, has very, very specific rules about all areas of commerce, and estate planning is no exception. Every system of law has a default succession plan, what happens in the absence of a will. Under halacha, under Jewish law as well, there are very specific rules. One of the things which is a bit unusual today, although historically it was common, is that the firstborn, the eldest son, known as Bachar, don't bother trying to pronounce that, actually traditionally got a double share of the estate, twice the amount of that his brothers received. That's just one example of many differences of the estate plan. Now, typically, tradition has evolved.
If I could interrupt for a second, that is what we would refer to on the civil side as an intestacy, right? Somebody dying without a will. So what you're referring to is the halachic version of intestacy.
Correct. But where that plays a role is that when someone's drafting a will and they're not intending to follow that default succession plan, they have very specific ideas of how they want their estate to be divided. Many of them, in order to honor that tradition, if you will create what's called a halachic carve out, and that is they'll put aside a small portion of the estate, which will be distributed according to that halachic default, if you will, and the rest of it they'll distribute however they choose or however their tax planner advises them to do so. So it's fairly common, while you're having this conversation, for them to bring up at some point, I want to put aside this what we call the halacha carve out, and this has got to follow different rules. Now, this actually raises some interesting, legal questions, and that is, in a perfect world, the simplest way to deal with that would be to write in the will that X amount of dollars or this specific asset should be distributed among my successors in accordance with halacha. The problem with that is the establishment clause. The last thing you want is a will to be probated and a civil judge to have to try to entangle and figure out what halacha says and who gets what and why and when and how. Legally, he can't even do that because of the establishment clause. So as a practical advice, what typically will happen is that there'll be a little bit of a carve out. What they'll write is that my executor or trustee, depending on what mechanism that's being used, will distribute that according to his discretion or in accordance with the wishes I've expressed to him, and then that there's a letter written expressing the wishes that halacha should be followed. And that way a judge doesn't have to determine what halacha is, but your trusted executor will make sure that at least in this halacha carve out is distributed according to your wishes. That's the first point that may come up. A second and somewhat more complex matter.
Can I just maybe we can elaborate a little bit as to what that carve out, like some examples of what a reasonable carve out would be. Is it a large amount, a small amount? The people maybe are there different traditions in how much of the carve out should be distributed according to the halachic rules?
Well, it does depend on the size of the estate. It should be an amount that has some level of significance. It certainly should not be large enough that anyone will fight over it or feel slighted and create any sort of tension in the family. But it very much will depend on the size of the estate, and that's something which there are different traditions and different approaches. It would literally be malpractice for me to put a dollar amount out there for on the internet, because it's not a one size fits all. But the second aspect, I think, which is important for an attorney to know and to be sensitive to, is every legal tradition has rules about how to distribute, how a will is written. There are procedures. Every state has different procedures, witnesses, notarized, different requirements for it actually to be binding and for it to be effective. Halacha as well has a fairly complex set of requirements as to how a will, it's known actually as a tzava, has to be drafted in order for it to be successfully change the intestate or the default succession plan. Your clients are not going to come to you to manage that tzava to make sure the will or the trust complies with Jewish law. That's it's a technical area that's not what you learn in law school. He'll go to his rabbi for that. But you'll end up with a bit of a unique situation where, on one hand, there's a will, there's a trust that's expected to be that's there to protect everyone in civil court and to minimize the tax liabilities. At the same time, they may have gone to their rabbi to have a tzava, an alternate document written up to make sure this plan is enforceable as a matter of halacha under Jewish law. Now, I typically don't mix the two. When I'm writing a tzava, I say I'm going to do this. Don't have the attorneys involved. I'm not going to get involved with what they do, other than the halachic exclusion. And the reason for that is that there are some aspects of halacha which can create all sorts of liabilities under civil law. Sometimes the gift is given a moment before death, which for religious halacha, that's very helpful. If you want to be very technical, that can have all sorts of tax consequences. So my advice to people when they're writing a tzava is to make it clear in the document. The point that I was making was that the same way, or every legal body has rules on how to write a will, how to write an estate plan to make it enforceable. There are very technical requirements in many states. Halacha as well has specific requirements for a will or a tzava to be enforceable and for it to actually be effective. And therefore, clients will very often, while they're turning to their attorney for the will, for the trust that will be probated, that will help out from a legal perspective, they will go to their rabbi to make sure that what their wishes are carried out from a halachic perspective in the Bezdin as well. Now, typically when I
think that it would survive a challenge. So just like we're doing our documents to wait, to make sure that it would survive a challenge in a secular court, then the concept is, okay, we want to prepare a set of documents that make sure that this estate plan would survive a challenge in a halachic or a Jewish court. Is that
certainly? As I mentioned earlier, halacha has very specific rules about financial matters, and Orthodox Jews, if there is a question or if there's a dispute, will very often litigate that in a Bezdin arbitration panel, and therefore your estate plan, you want to make sure that as a matter of halacha, it's going to the people who you want it to go to. So that's the purpose of a tzava. And the way a tzava is written, there are all sorts of aspects of it that are not necessarily consistent with what your legal estate planner will recommend. As a result of that, I advise anyone to make it very clear in the tzava, in this religious doc, that is for being executed for religious purposes only. And that way you're signaling to the judge that this document is not intended to change the economics, it's not intended to change the legal or the tax ramifications, it's there to allow the testator and his family to comply with religious law. And the hope is then the judge won't delve too much into the technicalities or things that need to be done for religious compliance. Again, I'm not an attorney. This should not be construed as legal advice. I'll leave that to everyone else on the call.
So Sheldon, there's a will and there's a revocable trust, and then there's also this religious document that a rabbi drafted that is showing the intent but may not have legal force and effect? Or do you divert 10% of the assets to this separate document?
right? So there are really two parts. So there is that carve out, which may not be 10%, can often be less, which is going to be referenced in the legal set of documents. And it's going to say, like Rabbi Marburger said, I leave X dollar or X percent to my executor or to my trustee to follow my intent and distribute these assets in accordance with my wishes that they be distributed in accordance with the Jewish law. So that would actually be done on the secular side. Okay, then what's going to happen is there's going to be another document, a side document, which is going to be authored by a rabbi. Rabbi Marburger has a very very well detailed, very well thought out addendum. And what that is going to say is that it's going to take care of the religious aspects of it and ensure that from a religious side, this estate plan would be upheld as well. So that really, there's sort of two parts. One part is that the estate planner is going to do, and is going to incorporate in his or her documents that carve out, that what we call the halachic or Jewish law carve out, and reference it for religious purposes. And the second part is going to be done with that religious document, which is going to ensure that everything, it doesn't change the estate plan. The estate plan is going to be the same. It doesn't say, well, in my legal document, I said, my children in equal shares, but in my halachic document, I'm saying otherwise. It's saying exactly the same thing, but it ensures that the formalities of execution will be valid in accordance with halacha as well. So it often can be just a short 2-page addendum. It may not have to recite everything again. It can just incorporate the will and the trust. But the point is that it allows the halachic formalities to take place in a way that they're halachically binding and correct as well.
A little bit of interesting New York background noise there.
Okay.
Yes, sorry about that.
So Sheldon, what else is different when you do an estate plan for a typical Orthodox Jewish family?
Okay, so
What else do you have to pay attention to?
yeah, so like Rabbi Marburger said, there's a very broad range. Just practically, you may be dealing with families that are larger than the typical American size. You may have families, with 10 or more children, a lot of grandchildren, which those of you that do estate tax planning and like to use crummy withdrawal rights, that can be extremely helpful. But just realize that there are a lot of people, and so there's a bigger dynamic. There's nothing that you need to sort of know religious education. It's not a religious education, but it's just sort of a social awareness, and you're going to try to navigate that family just as you would every family, just keeping in mind that that family may be just a lot larger, have different dynamics. Often families are very close and all live near each other. There may be children very involved in their parents' lives. Parents, often when they get older, may live by their children. That's something that'll come up, and you may want to discuss, well, if a parent moves into a child and the child puts an addition on his home, what happens to that addition after the parent passes away? So it's more of keeping an open mind and just using your good judgment, but being open to the different issues that come up. I would also add many of the, I would say, more ultra-Orthodox families, children will not attend college, and so the incentives that you maybe build into your documents to provide for college education may or may not be appropriate. A lot of the families, their children may stay in advanced Talmudic study for a number of years after their marriage, with the parents helping them financially, allowing them to do that. And so that might be something you would want to think about building into the estate plan. But ultimately, it's just about getting to learn this family just as you try to get to learn every family that comes across your desk or it comes into your office, and just, and being open-minded and using your common sense to learn the issues that are important to them, and not to make assumptions, probe and ask until you get a good sense of who this family is. I think that would be the best set of, of guidance that I can say. That's in terms of the estate planning. I know that there are other issues that come up. One of them is very much in Rabbi Marburger's wheelhouse, so I'm going to bring it up and ask him to address that. And then I would like to discuss a little bit the healthcare proxy and living will. Often estate planners, we use promissory notes. Often we'll do sales to trusts. This is one of the tricks that I've learned from Alan, how to sell assets to a trust in exchange for a promissory note. That promissory note is interest bearing. And in Jewish religious law, there are certain prohibitions against lending money or owing money with interest. And that's something that, again, your client may not even be aware of it if you don't bring him up to it. So the assumption that my client is religious, he knows what to do with his religious life, you actually, as the estate planner, who may not be practicing or not be Jewish, you may know more about that than your client. So, Rabbi Marburger, what is important and what should be brought up if there is a debt that's interfering?
Okay, it's an excellent point, Sheldon. So the idea or the challenge is there is a concept known as Ravis. Everyone's getting a little education on Jewish jargon today. But Ravis is loosely translated as the prohibition against charging interest. Now, as you mentioned, the context of estate planning, a very common tool is to sell an asset to a trust. And for legal purposes, you typically do have to charge some interest, even though you want that to be as low as possible for estate planning purposes under normal circumstances. But that ultimately there is interest being charged from the seller to the buyer, and that creates a potential Ravis concern. Now, here already there's a threshold question, and that is some opinions, some halachic opinions, maintain that the Ravis does not apply to unless there is a loan to an individual, unless there's a personal liability on this obligation. Now, in the context of estate planning, where you're putting something in a trust, it's almost unheard of for there to be any personal guarantee. The whole idea is to sell it to the trust, and it's an obligation of the trust, not from any individual. So a fair amount of clients will say there's no personal guarantee. It's an obligation of a trust. Although the beneficiaries may be Jewish, we can safely ignore the laws of Ravis, and a fair amount of the clients the conversation will end there. Not everyone relies on that opinion. Anyone who's familiar with the Talmudic discourse knows that there are very wide range of opinions on almost every matter, and therefore some people will find that objectionable interest is being charged. They will set up what is known as a heter iska. That is a certain device. It's loosely some form of financial engineering, if you will, that recharacterizes the transaction. It's no longer a loan. It's some sort of equity transaction. The details are really beyond the scope of this conversation, but people who are concerned with Ravis are typically familiar with the heter iska. They know where to find them, and don't be shocked if after along with all of your very carefully prepared legal documents describing the debt and the interest and the obligation, there's this other one pager that they add in that say, no, it's not a loan, it's a joint venture. Very standard, although again, a little surprising if you've never seen it before, but something just to be aware of and something to just bring up to your clients. They should think about it in advance. They'll need some sort of documentation to get that done before December 31st.
Right. And I know, Rabbi Marburger, a lot of attorneys we're very sensitive to something that a document that may recharacterize what we've done. So I just I think maybe it's important to reassure the audience that I know you've been advising some very large, on very large, very sophisticated transactions with very large New York firms, and all have gone through this heter iska, and it's it can work from a legal perspective as well.
Yeah, so the working assumption, and again, to be clear, this is not legal advice. The working assumption is that it is very clear from the document, just from the face of it. The parties will spend weeks, tens of thousands of dollars on legal fees, negotiating promissory note, mortgage notes, everything that security, UCCs, everything that says debt, interest. They'll then sign a heter iska, which they've probably downloaded from my website. Typically, a judge understands this is being done for religious purposes, and at least in all the case law that I'm familiar with, they've ignored it. Everyone takes it off on their tax returns as an interest expense. They don't look at this as a capital gain distribution. So that certainly is the working assumption of many banks, hedge funds, family offices, etc. But like I said, you have an attorney for a reason, so run it by them as well.
Understood. Okay, thank you. Okay, Alan, any other questions before we get into the healthcare and living will.
Yeah, Sheldon, are you using an arbitration clause that puts them in an arbitration that Rabbi Marburger becomes Judge Marburger in an actual legal dispute? Is there an arbitration? Is there an Orthodox Jewish arbitration tribunal somewhere? And should that be?
There are many of them, right? There's one in Lakewood, obviously, where Rabbi Marburger is, but I don't often say who the arbitrator needs to be, but the standard trusts that we do will provide that any disputes be resolved in a religious arbitration as opposed to a secular court, correct? With wills, you get into issues because under New York law, I don't know what it is in Florida, but as a matter of public policy, often the arbitration clauses would not be upheld. But in trust, it's definitely in there as well. And the expectation is that if there was a dispute, we hope that clients would go to a religious arbitration.
Sheldon, if I could just jump in for a moment. I would suggest, or I always advise people to have a dispute resolution clause specifying a Bezdin, an arbitration panel, if that's their wishes. And as a matter of policy, it's a very good idea to be very specific, the specific rabbis or panel that you want. And the reason for that is, as we mentioned earlier, the word Orthodox Jewish family has a very broad definition, and Bezdin, religious tribunals as well. There is a wide range of panels out there, and if you or your family are going to be comfortable in one specific one or not comfortable in a specific one, it avoids a lot of potential heartache down the road. To be very clear, this is the panel that I want or that I trust to be able to resolve any particular dispute that comes out.
That's a good point. Thank you.
So one more question. Are there any rules of thumb or normal patterns of conduct for charitable contributions? You know, some people tithe a certain percentage of their income to a particular church. So are there any rules of thumb or anything like that that we should be aware of?
Right, Marbury, do you want to respond first?
Okay, sure. It is very common in Orthodox Jewish families for people, especially if they're more affluent, to be very generous and to, throughout their lifetime, supporting various charitable endeavors. When people come to me, I actually push them very hard. Don't wait until you die to give to charity. Give it today. There's a need today. Give it today where your children will learn from your example. It's a bit easier to read it right, to leave it over in a will because it doesn't cost you anything, if you will. So I push people very hard not to wait until then to start their generosity. But your point is well taken. Very often people will leave over a percentage, whether it's 10%, sometimes it's even 20%, to specific charities, or if there's enough wealth in the family, they'll create a foundation, which they'll very often want their children to be involved in supporting the institutions that were dear to them.
Very good.
That's correct. We find the same, and also encourage people, once they go through the process of identifying, they say they want to leave to charity, especially, sometimes you have families that don't have children and they'll say, okay, I want to leave it to charity. And then they spend a lot of time sort of thinking about which charities are really important to them. And then the conversations become, okay, now that you realize what's important to you, why don't you get involved today and actually enjoy seeing what your money can accomplish on the charitable sense.
Very good. Okay, so I know, Sheldon, you wanted Rabbi Marburger to tell us about living wills and end-of-life planning.
Yeah. So I thought actually that I would discuss that a bit. So I think that the basic point is that there's a very standard living will that most attorneys provide for clients, which often will say something like, if I am, God forbid, in a state, an incurable state or a vegetative state or a state where I no longer have quality of life, I basically do everything you can to end life as quickly and as painlessly as you can. And there's a very strong focus, it's a cultural focus on quality of life. That, you know, a life that doesn't have the quality that we determine is quality, then, you know, it's not necessarily worth living. And from a Jewish law perspective, it's very different. So life is life is God-given, and it's meaningful. And every minute or second of life is infused with the meaning that God gave it and God willed it to happen. And it's not necessarily it's not something that we can choose to end. It's not necessarily saying that a DNR is never allowed, or a do not intubate is never allowed. A withdrawal of treatment may be allowed, but the point is that they're very, very specific case-by-case basis for making those decisions at those times. And so to provide in a document that I don't want this, I never want this, I never want that, that is problematic from a Jewish law perspective. And so the standard, those standard living wills, the standard that most people have would be inappropriate for many clients, for the Orthodox, you know, Jewish clients. And surprisingly, I would say many of the clients don't even realize when they're signing what exactly it is that they're signing. And so I think what's important is to I shouldn't say many, but a couple of organizations have spent the time and really worked through a living will healthcare proxy that is halachically compliant. One of them is called Chaim Aruchim, again, two sounds in the word, but there's a link to the website at the end of the slides. And it is a organization that is dedicated to helping people with end-of-life halachic issues, both from a legal perspective, because often often a Orthodox family will find themselves at odds with a medical institution or a medical professional who doesn't share those values and is urging them to end life. And so they have people 24 hours available for advocacy and legal assistance. But one of the things that they've done, which, you know, any attorney can avail themselves of, is they've drafted a very specific halachically compliant healthcare proxy and living will adapted to the specific laws of each state. You know, there's a disclaimer. Obviously, as an attorney, you need to review it and make sure that the laws haven't changed or that it's appropriate. But, you know, the general thrust of the document is definitely compliant and can be downloaded from their website for free. What that document really says is that it appoints healthcare agents. It also says that decisions need to be made in accordance with Jewish law, and will name a rabbi or an organization that would provide the halachic input in the case a decision needs to be made. So I would appoint my son as the agent, but my rabbi or an organization as the halachic decider in case there's an issue, that in case there's a decision that needs to be made. They've been very helpful to Orthodox families in terms of end-of-life decisions where there's a lot of pressure, confusion, despair, and just they've been helpful to allow people to make the right decision, make the correct decisions at very challenging times. And like I said, they're available for free. You don't need a rabbi. You can download those for your clients. I know there's another organization called the RCA, I think it's Rabbinical Conference of America, I believe, has also done a very, very similar document, although I don't know if it's adopted for all 50 states in the same way. And I guess the last thing is post-mortem decisions also have halachic consequence. Cremation is something that's not allowed according to Jewish law, and something that's looked at as also very harmful to the soul of the individual. That's something that also would be provided in these types of documents. that post-mortem decisions need to be made, and need to be made in accordance with Jewish law. So that gives a person sort of the confidence that not only his financial decisions are done correctly, but also his healthcare and end of life decisions are done the way he or she would like them to be. And the website is a great resource, and like I said, they have a 24-hour hotline that's for anyone in a crisis.
What about, I want to talk a little bit about ritual of what happens with the body after death, and sitting shiva, which is a little bit different than what most other people do.
Okay, so I'll tell you what I know, and in full disclaimer, I'm not part of any burial society. I actually, when I went to law school in St. Louis, there was a need for people to involve themselves in that, what we call chevra kadisha, which is the people that prepare a body for a burial for religious things. But to be honest, I chickened out. But what I know is that, first of all, there's burial, so as opposed to any type of cremation, it's in-ground burial, and very much a focus on simplicity. So there wouldn't be like a showing of the body, a wake, or dressing up, but everything in very simple linen white shrouds in a simple pine casket, which is then buried. More than that, I don't. And the body, there are certain sort of washing, purification, washing process that the body goes through, and certain special prayers, etc. But I think the main thing is that every Orthodox community has its burial society, which they call chevra kadisha, and they know what to do, and those are the people that sort of take care of that.
Then the mourning process, as far as sitting shiva, and then 1 year after death.
Right. Okay. So again, a lot there. The family, the immediate relatives, so that would be children, spouse, siblings. Hopefully not, but sometimes parents would sit shiva, which shiva is a Jewish word for 7. So it's a 7-day mourning period where the family pretty much stays home, observes many rituals, but it's sort of a time of comforting where friends and family sit and spend time and reminisce about the person that passed away, and provide comfort to the mourners. And those days are very much solely focused on that, on mourning, on discussing the virtues and remembering the life of the person that passed away, doing things for that person's merit of his soul, and being solely focused on that person. That's sort of the most intense mourning period. And then there is a 30-day period, which is a little more intense. And then there's a 1-year period, which is less intense and has different obligations for different people. But there, for somebody that needs, I think there are very good practical stuff out there, practical books out there. I know ArtScroll has published, and there are others, very practical and helpful books. Right, Margaret, do you want to add anything to that?
No, I think you've done a good job of giving an overview. Your clients may show up for a year not very well shaven. That's also part of the mourning period. But there are many different customs and practices. But I think you've done an excellent job giving an overview and a little bit of insight what goes on.
Sheldon, anything else you want to mention before we go towards a close here?
No, thank you everybody for listening. Thank you.
I have a question. Sheldon, you gave me a book to read, and I read it.
Okay.
And one thing that I was very interested in was customs and rules relating to speaking ill of other people, even if it's truthful, or giving big compliments to people. and a very careful approach to that. And I'd like, Rabbi Marburger, what is the advice that you give on the pulpit with respect to that? Because it may be just a little bit different than what Dale Carnegie said.
Fair enough. The advice is to be as careful as what comes out of your mouth as what comes into your mouth. I'm going to talk now not so much as a pulpit rabbi, but as an arbitrator who deals with disputes all day. The damage that can be done by just a loose word is enormous, and there's no unringing that bell. People can have disagreements, especially when it comes to commerce. People have different vantage points, different needs, different ones, but being careful how you talk, not to use any inflammatory language, not to get personal, just deal with the issue at hand. If people would follow that advice, they'd have a lot calmer, stress-free, and I'd have a lot more time on my hands because I wouldn't be busy cleaning up everyone else's messes. I just thought I had an interesting conversation with a law professor who was very strongly advocating for free speech. And the conversation had to do with hate speech on Facebook and on social media platforms. And he was taking the position that this is, free speech. That's what America is based on. And we have to give people the right to talk the way they choose. And I counter that I know this sounds old-fashioned, but there are laws of Lashon Hara, if you will, that have been around for thousands of years that made very clear. You're allowed to speak up. You should be objecting if you see something wrong and that you disagree with, but do it civilly and do it with respect. We didn't get that far in the conversation. He held his, I held mine. After January 6th, I just sent him a little reminder email that perhaps now he'd reconsider the effect of just unrestrained speech, and perhaps we'd all talk a little bit more gently. The country would be a much better place.
Very good. Okay, so we have the email addresses here for Sheldon and Rabbi Merberger, and you have my email address, but only send me easy questions. Send them any difficult questions. If you would like to see a part 2 of this, if you would like to give us an agenda for part 2, we'll be more than glad to do it. It's a fascinating area, a fascinating group of very dedicated people. Thank you once again for attending, and I hope the rest of your day is really, really nice. Thank you.
Okay. Thank you, Alan. Thank you, Sheldon.
Thank you, everybody.
Thank you.